I gotta move closer. There you go. Yeah.
Good evening.
Good evening.
You are live with Courtside with Lawman
and Carmen B.
And we are here to discuss criminal law issues that affect the community. Our purpose is to provide information to answer your questions. We are educational and an informational program for the public.
Yes.
If you do call in or email us or send us a question in the chat, we will answer that. But our answering of that question does not create an attorney-client privilege between myself and the caller or Lawman, Mr. Staten, and the caller. But we do appreciate your calls and your comments in the chat. And we will try and answer those questions as best we can.
And we hope to discuss some issues tonight about changes in criminal law, things that we should be aware of. And I believe we'll touch in on the Derrick Chauvin sentencing that occurred today. Just briefly, I think. Or at least we'll discuss, and because a lot of people will wonder, is it a fair sentencing? And you know, what does it really mean? How much he'll do? Things like that. And I know that, let's see, we do know that, let's see, where are we getting? We're getting near the end of June here, the beginning of the summer months. And I think last year, a lot of people were inside, and right now, things have changed since June 15th to where we're opening up our society a lot more. However, we have had some rules regarding what the courts will do now as they open up the doors to the courtroom. So we'll probably go through a few of those things. What are the restrictions now in the courthouse? I believe that we're probably going to keep the Zoom system. I'm pretty sure.
And right now, Lawman is talking specifically about the changes that we are seeing here in Sacramento County.
Right.
If you are out of state
or out of county,
the changes may be different. So you'll have to check what's going on in your local area.
And the easiest way is to get on the website for Yolo County, Placer County, El Dorado County, whichever county it is, and thoroughly review their website as to their new rules. Because some counties had opened up far earlier than others.
Yes.
And some will be probably more restrictive.
And even looking at the website, it's unfortunate, but websites are not always completely updated. So you may even want to place a call to your court to find out what they are actually doing there.
And if you have a lawyer that you know that you have, even check with them also, because a lot of times right now, what we've seen is they've been allowing a lot of lawyers to appear for their clients, what's called 977 of the Penal Code, which means that your client does not have to be present. And so that may change drastically, and then you're forced to appear. So definitely check with your lawyer on that kind of stuff. If you got court appearances you got to make. So where should we start? You want to start with the whole Derrick thing? Get that out the way?
When you say the whole Derrick thing, you're referencing the sentencing of
Derrick Chauvin,
the murderer of George Floyd.
Yes.
So I have a question for you,
yes.
Lawman. I have a question for you. What is a Black life worth when you take that life in front of essentially the world because it was recorded?
Yeah.
What is that life worth?
That's an interesting concept, because we are always struggling to wonder what a life is worth. If we take it that every life is the same and every life is worth the same, there's never a value we can put on it that would be a punishment for taking it. Some people in a manslaughter case could take a life 3 years. Vehicular manslaughter could actually be a misdemeanor, year county maximum. But here, they found him guilty of murder. They could have probably been at 30 or something like that, but it looks like they came to 22.5 years. Now, compare that with, let's just say, second-degree murder in California, and that would be 15 years to life. First-degree murder in California, 25 years to life. So he doesn't get a life sentence, which means he will do a determinate amount of time. And that time minus good time credit will probably be something around 13, 14 years that he'll probably serve. Now, how much is it worth? We are never going to answer that question about how much a person should get for taking a life.
Well, when I ask that question, I'm thinking about the sentencings that I have seen of young men here in Sacramento County who have been convicted of taking a life, and that didn't occur, usually does not occur on video, usually does not involve people begging them and giving them the opportunity to not take that life. A lot of times it's something that happens
spur of the moment.
It's spur of the moment, it's a rash circumstance, that sort of thing.
Doesn't even have to be taking the life, attempting to take it.
Yes. And I see sentences of 50 to life.
Yes.
60 to life.
Yes. Okay. One big difference in this case is depending on the mechanism that's done to kill a person. If it's a gun involved, in California, we have our 10-20 life enhancement that we put on. Now, I said those numbers properly, 10, 20, and life. So what that means is if you use a gun in a crime, 10 years. If you use the gun and you fire it, 20 years. And that's on top of anything else. And if you use a gun, fire it, and hit someone, don't kill them. 25 to life just for that. So that's what I mean by you don't have to kill anyone, and you can get a life sentence easily in California.
Well, I know specifically, of course, of more than one case, but one case that I can think of in particular, where the young man just fired off a weapon, did not strike anyone at all. No one suffered any injury, and he was sentenced to a flat 25 years. No one injured. Bullet struck absolutely no one. Didn't nick anyone, didn't slightly injure anyone, no injury whatsoever. And he was sentenced to 25 years. That's more than what Derrick Chauvin is getting for actually taking a life while people were begging him not to.
And then the aggravation, the court found that was aggravation, doing it in front of children, being crass about it. Now, let's explain how that person could get 25 years. And you're saying it's a determinate amount, right, Carmen?
Yes, it is a determinate flat sentence. And how they got it, they actually got less time for the crime. The gun enhancement carried 20 years.
Yes, I was just going to say, a simple robbery with a gun and firing the weapon, not at anyone in the ground even, could be 25 years. It holds 25 years straight.
20, because you would get 3 years for the robbery. You could get
5.
Yeah, you could get 2 years, 3 years, or 5 years for the robbery if it's a second degree, and then an additional 20 years on top of that because of the fact that you discharged a weapon. Now, some people would say, well, that's good because that dissuades people from committing crimes. Yeah. It really does not, because most of these crimes are committed without much planning.
Right. And they're trying drastic moves sometimes, you just
out of desperation.
Right, out of desperation sometimes. So, and now the real reason why it's so different is because of our laws. We have passed laws regarding punishment for guns, and that is the use a gun, go to prison law. If people are 35, 40 years old, you might remember that we voted on that particular law. It gave us that 10-year enhancement, and they had billboards running around, use a gun, go to prison. They had commercials going around, use a gun, go to prison. They just didn't tell us how long of a prison sentence you would serve for just the gun.
I don't recall specifically seeing any commercials, because we are a society that watches a lot of television. I do recall seeing billboards on buses.
Yeah. And the commercials I'm thinking about is I think I remember, the phrase, being said, just quickly a 15-second spot, like use a gun, go to prison or something like that. But we have that law. We voted it in. And that is why we will see such disparate sentences when it comes to the use of a weapon, and its comparison to other states. Now, Derrick Chauvin alleged, we know the weapon would have been his hands, and knee and things like that. So it's not necessarily the gun enhancement or anything attached. Now, what if though? Here's something to throw out. What if we had almost the same situation, but at least we got a situation where an officer did use their weapon in California? You see, would that gun enhancement then, apply? And would that then ratchet that sentence up to maybe a life offense? It has to be.
Are you aware of any circumstances where an officer has been charged, where they charged is the first
and
hurdle?
Convicted.
Once you have an officer that kills someone,
Right.
it is the hurdle of even getting them charged. And then what actually, if they are charged, what they would be charged with?
They were throwing a stat around today on TV about how there have only been 16, I guess, convictions of officers or something like that over a certain amount of 15, 16 years or something like that. And
is that for any crimes? Because we've seen all sorts of scandals. We had the Rampart scandal. We had the in Oakland, the officers who were basically molesting a child who was being sex trafficked.
And I think it was narrowed to when officer has either killed, a civilian, or something like that. So, but very few over the last 16 years has any cops ever been convicted of such a thing. And one of the problems is, California it's very rare that you'll see that officers are prosecuted for anything. And that is a part of how the district attorney's office, the AG office, and I guess you could say the U.S. Department of Justice, how they view the function of reviewing officers' work. We know you can take any situation here, but if an officer does something, uses his weapon, and there is an allegation that the officer did so unjustly, an alleged investigation will begin. And then that investigation is rightfully in the hands of the district attorneys, first of all. Now, they can then punt it out to the AG office, the Attorney General of the state of California. And they might do that, and it would probably be proper simply because most of the district attorney offices have a very close relationship with the sheriff and the police department. In fact, although they are not what we call in privity, they don't work for each other necessarily. They work with each other tremendously. There are no prosecutions that will go on without using 1, 2, 3 police officers or more. So they are constantly called as witnesses to testify. Their cooperation is completely necessary. And if a district attorney needs an officer, they merely pick up a phone, call liaison, and say, hey, I need that officer in court. I need that detective here. And those detectives have to go. The officers have to go. So there is a strong relationship between officers and district attorney's offices. And therefore, the prosecution of individuals who are officers is sort of, how should you say, it's touchy because the message you may be sending. Now, the message you should be sending is do what's right. If something is wrong, correct it, prosecute, just like you would any other citizen, technically. But we know because of that relationship, it is very hard for the district attorney to have a independent view of what's going on. So in this case, you got to feel that one thing that probably was different was the office that prosecuted did not have that relationship with the local Minneapolis Police Department. We have to also see what's going to happen to the others, and how far will a jury go in assessing fault to them. And here's a bigger question, will what happened with Derrick Chauvin be introduced as evidence in the other trials? Can that come in somehow? The fact that he was found guilty And if I am an aider and abetter, or if you're saying that I aided and abetted somehow, some way, then the result of his trial may be relevant. But that's going to depend a lot on Minneapolis law. That's going to depend on the prosecutor's theory and how they want to go after the other individuals. But for now, we have a 22.5-year sentence. And it's never going to bring Mr. Floyd back. Nothing ever will.
We have a comment in the chat. And before I read that comment, if I could just remind everyone, if you want to call in to courtside, the phone number is 916-384-8204. Again, 916-384-8204. There's a comment in the chat from April. What happened to the officers regarding Stephon Clark's case in Sacramento? Well, lawman, I'm gonna let you answer that.
Well, after a long time of pursuing it through the AG's office, who took over the investigation, they were found not to be at fault and did not have charges lodged against them.
They were basically found to have acted reasonably under the circumstances, right?
Yeah, using reasonable force, against what they may see as a threat to them.
So basically, doesn't that create in the officer's mind a need to, if he's in that situation, to yell out the words gun, 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 no matter what he sees, because then he can rely on that. My body cam shows that I believe that the person had a gun, and that's why I fired a shot.
They could. Of course, people can, and that's why, you see, okay, let me act like a defender of the police at this point, okay? Just so that we can get the dialogue down. So, are you saying that I can't reasonably believe that somebody's firing a gun if I see a flash at night?
Under those circumstances, no. I don't believe that you can automatically just assume that any flash is a gun, is a flash from a gun when you've not heard any sound. There was no report that anyone had a gun. In addition, one of the problems that we have in American society and public, we have to be willing to talk about this. We can't brush it under the rug. It seems that officers are more likely to see the item as a weapon when they see brown skin. There have been studies done that where they have shown people photographs that show a person numerous people, and then one of those people has a weapon, and they're people of different races. And there's even one where the person who actually has the weapon is a white person. But when they go back and after they've shown the photo, and then they go back and they interview the people and ask them which person had the weapon, they are more likely to attribute it to the African-American person. What does this say about our society? That having brown skin has been criminalized to the point that psychologically people will see things that are not there.
I think that's been shown also in our Karen activity of people just making things up. It's been shown in the whole fear thing, like a group of us together, there's sparks some fear to a neighborhood or to society. If I'm just parked in the Fabulous 40s in my car for a while, how long before not only a citizen, but maybe an officer may stop by because someone says, hey, that guy must be doing something because I don't recognize him and he probably shouldn't be here. So there's a lot of fear that's actually in our society of black skin, brown skin. And so here you draw something. Here's the thing. That's taking something and saying that, well, wait a minute. We don't want to process people to believe that. We're not trying to say that that's true or not true. And if you teach that it is true, or if you attempt to just put out there that that's true without any backing, well, now, you're race baiting. You see, you're just making up excuses and things like that. if you can't back it up with true facts, that somehow we're just trying to make black people evil or things like that. Now I'm taking, of course, I'm taking a side here, okay, so that we can have dialogue. But I'll tell you, that is probably farthest from the truth that there can be. But what we also got to know is that we live in a society that race does matter. And that's what the studies will also show, is that race does matter. But if we want to turn our backs to it and ignore it, well, then we'll continue to have a problem of race. Back to Chauvin, I think that what's going to happen in the cases that subsequently come is that those officers may end up taking a deal and or at the end. They've seen what happened in Chauvin. They may be afraid to go to trial now and decide on taking a deal. And that would be interesting because we haven't heard of whether or not that is a possibility. Now, someone asked something like, can an officer testify against another? Absolutely. Absolutely. In fact, when police are doing, or when DAs and AGs are doing their investigations of events, they are talking to officers primarily when there's an officer involved shooting or some incident. Recently, in the incident where the officer had fraudulently brought up the probable cause to pull a man over or to stop him, the reasonable suspicion, there were probably 25 officers who were interviewed by IA. And if that person chose to go to trial on their charges, the officers are going to be chief witnesses, and they will be compelled to come in and testify to what they know. So yes, officers can testify against other officers. And in fact, in Derrick Chauvin, they used a lot of expert officers, individuals on force and things like that, in order to come in to say what reasonable police officers would do and how they would act. So yes, officers can always do that. So let's see, what else is happening out there?
We have a question from Sean. Can another officer testify against another officer?
That's what I was just talking about. Mm-hmm. The answer is absolutely.
Yes.
Definitely. In fact, I mean, sometimes I call officers in my case because they may have a different view of something than another officer. And so I know that they're at the scene and they wrote their report and it differs from another officer. I'm going to call them to impeach another officer. So definitely.
Yes.
But
we have another question from and I'm sorry if I mispronounce, but I believe it's Kamar Din. Was the verdict sensible in context to the appeals process? Personally, I believe the judge has sealed Chauvin's fate, mitigates the defense arguments around the public, civic, and political pressure.
I think I'm going to take it. Let's see. Verdict sensible in context to the appeals process. Meaning, can this case be appealed and overturned, so to speak? Now, every case, of course, he's going to file an appeal. In fact, they ask for a new trial right before the sentencing, and that's not uncommon. Lawyers have to spew out anything, basically, at the last minute in order to try to get a new trial. And what they're doing is they're laying a record for appeal. So if you make these arguments now, then on appeal, those arguments must be dealt with. But that does not mean in any way, shape, or form a case is going to come back. And the way that is usually guaranteed is it depends on the skill of your trial judge. If your trial judge has to really be good, your trial judge has to know the rules of evidence and rule appropriately. And if they don't, then it's the lawyer's job to always make a record about why that judge was wrong and saving that issue for appeal. So you got to believe that in this case, I am sure the prosecutors as well as defense made all objections they could and dealt with anything that could have been objectionable and had the judge rule on it. Yes. And the judge was probably certain about all of their rulings. So to at least lower the effect of an appeal.
Protect and Provide commented, it is hard to prove that someone loves or hates you. It is also hard to prove who is racist and who is not.
That's right.
That is true. But sometimes the actions of the person will show you whether they are racist or whether they are not.
And this reaction, a lot, too, I guess, right?
Yes.
How you react to someone, who comes around. And go ahead.
Protect and provide further comments. That is why it is important to let racists use social media so we can prove that they are racist. That is something to be considered, right? Because I think a lot of there were a number of officers whose racism was discovered as a result of posts that they had placed on social media in reference to the people the neighborhoods that they were policing.
That is true. In fact, this week, an officer, I believe it's Michigan. In fact, two things happened in Michigan today that kind of is weird. Two things. Number one, we know that the officers killed a 19-year-old girl who allegedly fired at the officers, and the thing is on videotape. On the one hand, and the big thing was the officer was crying afterwards and stuff like that and broke down. But he actually, I don't believe, fired his weapon. I'm watching, he didn't fire his weapon until people fired.
Mm-hmm.
Now, on the other half of that was a lady who was engaging with a Michigan officer, and he was on Facebook. And he was raging about something, and his thought process, or at least what it led up to, was him saying that he would rather die or kill himself if he was Black in America. And it was after a lot of racist comments, of course, but his theme or his theory was, I'd kill myself if I was a Black man in America. And a lady took offense to it and reported it. She found out he was a peace officer and sent it to his place, and they fired him for that because they viewed that as racist comments that we do not want to promote. But it got me thinking, you see, social media brings out a lot. There are so many stories and stuff of the officers talking amongst themselves on the job, probably even on their own recorders. And they are talking the most evilest things, like I remember, just wait. I can't wait till the race war starts, so I can go out and kill Black people. Just very blatant comments and stuff like that. One New York City guy who had retired said, "You're going to see the real me now," and stuff,
Which I'm sure many people that he arrested probably had to deal
seen
with
the real
him.
And but he was accused of going around pointing his weapon at Black people as they drive around, like he was going to shoot them and stuff. So, yes, social media is so important to trap people, to get them into dialogue, and then the real person comes out. And I think I know we don't have anything formal, but there might have to be a watchdog group, that actually is out there in cities who would report such things, look for such things on all platters, and then start reporting like that lady did. She was in a banter with him on Facebook, and she stopped and said, "Wait a minute, let me look this guy up." Turns out he's really a cop, and then sent it all to the thing, and bam, they fired him right away. So that was two things in Michigan alone in this week that occurred that just seemed to be a left and a right. The guy just coming out just saying, if he was Black here, he'd kill himself. And then the officer who shot the 19-year-old, and he was literally begging not to shoot, don't shoot. And she did, and he shot her. And he did break down, And so it goes to show, your emotions can go both sides. And it brings up that thing of fear of us, I mean, I would be willing to say an officer's not going to let me pull a weapon and point at him, and we have some sort of Mexican standoff, as they say, in the movies and everything.
Not likely to happen.
That is likely not to happen. I think
if you pull a weapon, we know what the outcome of that is going to be.
Right. And here, if you see it,
you won't get that
the benefit of the
doubt that is provided to others in the same situation. And I think that we have all seen the videos on the internet where there is a
white guy and he's carrying a rifle around or something, or he stopped him and he's got a gun
And he's
And he
given
pointed at them.
multiple
Yeah.
opportunities
Drop the weapon.
to
do
put the
this.
weapon down without
Yeah.
being shot, without being killed.
Right.
And those same opportunities should be provided to African Americans who aren't even armed, or any citizen. Because again, if this United States is to survive, it has to survive with all of us.
And it brings up, I'm gonna tell you, the Michigan cop thing, right? Brings up what we were talking about last time with James Baldwin, you know, and what he said, the first thing that he had said was one of the biggest things, one of the biggest lies in America. And what he said, white people know for sure, what they really, really know is that they do not want to be black in America.
And why would they know that? Why would they know that?
Because they
see the experience.
Yeah, they know the experience. They know that this place may not be friendly to us. That and yet what you're going to probably hear though from the other side is that we are killing each other off and breaking each other down so much. That's why I wouldn't want to be a black person here. You know, they'll shift it to the violence is not coming from white America or any supreme race or anything like that. It's coming from within them.
Yes.
To each other as the justification.
Now, one last thing on the Derrick Chauvin thing before sentencing, before we move on. Do we know what the good time credit is in that state?
I don't know for total sure. I'd have to look at further in some articles.
Good time credit, for those of you who have had no contact or involvement with the criminal justice system or who have never studied it, is additional time credits that are awarded to someone that is in custody, separate and apart from the actual days that they do. They can earn additional credit. They're referred to as good time credit or good conduct credit. Correct. And so in California, it is depending on the crime as to the credit. There are a lot of felonies where it is 50% credit. Right. So if you're given a year sentence, you serve 6 months of that, and the other 6 months is good time, as long as you don't get into any additional trouble, you don't get any write-ups. Right. If the crimes are violent crimes, it's 85% per law. Per the change in Prop 57, it was reduced to 80% of the sentence. And then right now, as we talked about at our last show, there is additional credit that is currently being given by CDCR, but those credits are not a change in the law. So at any point in time, CDCR could decide that they're going to pull back that additional credit.
Right.
There are a few other major things going on.
Oh, yeah. The Fourth Amendment issue? Yes.
Yes.
Oh, that's a good one.
The Supreme Court restricting the police powers in entering a home without a warrant.
Yes, because generally, if the cops are chasing a felon, they can go into the home to chase that felon.
Yes.
They can enter that home without a warrant. Otherwise, you need a warrant.
Yes. So if they're chasing a felon, that's a circumstance that is seen as an exigent circumstance. That person could be a danger to the community, and so they're allowed to danger. Yes, they are allowed to pursue that particular person. But what the Supreme Court has said, and I think the circumstances in this instance
came out of California. Here.
The gentleman was actually driving. They suspected that he might be, I think, under the influence. Yeah,
I think the officer saw him come from a bar, but he followed him. He didn't pull him over. He just followed him all the way into his garage.
The gentleman got to his garage and then drove in and then ran inside of his house, and the officer followed inside. The officer did not suspect that the person had committed any type of felony crime whatsoever when he went into that home. He had no reason to believe that anyone was in danger, and he went into that home anyway.
Right.
And the court found,
Supreme Court of the maybe a Fed since it was a Fourth Amendment issue, into a Fed circuit court.
Yes.
And then to the Supreme Court of the United States.
And so that applies to all
everybody.
States.
Yes.
Yes.
And the court found that no, your home is your castle. The Fourth Amendment protects your home from all searches and entry unless there's a warrant. So you should never let officers in without a warrant. And what this is saying is that if you're not a fleeing felon, if there is no danger going on, that if you enter into your home, once you get home, then ollie ollie oxen free, right? It's sort of like that's home base, that they can't come in without a warrant because they can go write one if they have the cause to do so. So this case was striking because people thought, and the opposition thought, that they were now taking away that exigent circumstance whereby they can chase a fleeing felon. But the court was very clear in saying, look, we're not taking that away. We still understand exigency and fleeing felons. We're just saying, in this particular situation, when there is no felon that is fleeing, when there's no felony that has occurred,
there's no facts that show that anyone is in any type of danger,
then you go into your home, the officers can't follow you.
Now, again, that's in theory. Let's talk about in reality. The officers may actually follow you into your home. And then that is where we come in as the attorneys. If there is a case filed against you,
that's right,
to suppress that illegal entry into your home.
And that's why you shut up and you say, I want my lawyer. That's all you've got to do.
Those are the words we need you to remember.
Absolutely.
Am I free to leave? Am I free to go? And if the answer is no, I would like my attorney.
Lawyer. That's right. I
Nothing
want my
else
lawyer.
Beyond that.
And I'll tell you something. I had a motion that I fought just yesterday. And the facts of the case dictated, and I mean, it called for what I always preach. And because my guy didn't do it, the judge was able to determine when a detention occurred, and therefore he had some reasonable suspicion because it drew out the timeline before the detention occurred.
So the judge found that the detention in your case was reasonable?
Yes. And it's let's see, how much time? What are we working with? Okay, 6:39. Let me tell you, because I'm going to use this thing when I preach about this. And this is why the only thing to say to officers is, am I free to go? Okay? Now watch. Officers are chasing a motorcycle. There's a call, motorcycles are running around. Officer's chasing one. He actually chases, motorcycle turns around, he loses it.
Let me stop you right there.
Yes.
Are you talking specifically about your case or hypothetically?
It would be hypothetically.
Okay.
Yeah.
So be careful on the
They're
details.
chasing a motorbike. You see, come make calls, right? So when the officer comes down the street, they see some people standing outside, and they're just standing outside by a car. The officer, though, would approach and say, hey, where did these people go? The officer pulls the car over. Where did the
people go who were on the motorbike?
Right. Where'd they go?
Mm-hmm.
I saw them come this way, right? And the people don't say anything. And then they ask right away, well, hey, are you on probation parole? And then there's nothing, according to the officer. So an officer goes back to his car, and officers can do this. They can run your address and find out who lives there, who's on probation or parole.
Yes.
And and they can come and let's do a probation search based on such a thing. Now, the point of it all is when the officers are talking to the individual. So this could be, I'm at a baseball park. I'm anywhere. You're hanging with people. You're just hanging outside your house. And the officers come by and start asking questions. The first thing should be, are we free to go? Because if you do not say that, they can continue to investigate, and the court will view that as consensual conduct. Because I would say you're detained when an officer tells you, are you on probation parole? Because I wouldn't feel like I can now run, I can now leave. So I'm thinking I probably should stay here.
But the courts will see that if you entertain and you are just engaging in discussion, they will see that as having been consensual contact.
Right.
That is why you ask, am I free to leave? Am I free to go?
That's right.
If the answer is no, provide your identification, and
I would like
my attorney.
Because they can find that the detention is far more in time later than it would be right then and there. Because if the detention is right there, then the officer must have cause to talk to you, cause to I guess, suspect that you've done a crime. right then and there, not later on
Yes.
when they can go gather other information and stuff.
We do now have another comment in the chat from Zimbabwe Walker. What about so-called cause for suspicion entries of homes and vehicles? Is that applicable in real life or in this case, Fourth Amendment?
Yes, I think what you're saying is to get into let's say a home. We'll start with that. To get into your home, they got to have a warrant.
They either have to have a warrant or you have to give them consent.
Right.
And you can't let yourself be bullied into giving consent. For example, the officer will say, well, if you don't let me come in, I'm here, I think your son is here and I need to talk to him. Do you have a warrant? I don't have a warrant, but I need to talk to him. And if you don't let me in your house to check and see if he's here, then I'm going to have to get a warrant. And the response to that is go get your warrant.
Sure. Close the door.
Get your warrant.
Absolutely. All the time, all day.
Yes. Do not be bullied into consenting.
Right.
Because that does happen. Oh, okay. If you're going to get a warrant, and they will let you know it's going to inconvenience you. Yeah. It may take us hours. We're going to have everybody stand outside of the house. You're going to be waiting in the hot sun. Go ahead and accept that inconvenience. That's right. Tell them to get the warrant.
Exactly.
Your home is also your castle.
Right.
And let it be that.
So that's a home. Now, a car
is different.
Could be, because if you are driving on the roadway, then the officer should have some reasonable suspicion still that you've committed a crime, a violation, or something.
Yes.
Before even pulling you over. And what I'm saying is, even being lit up and pulled over, you have to define that situation. It isn't clear that the officer is detaining you, because an officer could do that and say, I just pulled you over just to let you know there's a picnic going on down the street and I'd like you to go to that and stuff like that. Or, hey, there's a rope hanging from the back of your car and things like that. Those are consensual contacts until the officer detains you. And that is why those words are important, because the answer to that is a detention, meaning in your car, you're driving, cop pulls you over. Cop comes up, may ask you, are you been drinking? Where you going? Anything like that. The answer is, am I free to go? Now, he just pulled me over, got lights and stuff flashing on me and stuff. But I'm defining the conversation right then and there. Am I free to go? I am now making the officer say this is a detention by asking, am I free to go?
Yes.
So you must do that, because
you don't need to engage in the conversation about where you're going, where you've been, where
have
you're
you been
coming
drinking,
from.
anything.
None of that.
And you've got to do that because of what may happen next and what he needs to do something next. That's when the officer must have a reasonable suspicion of a crime.
Now we're going to talk about, there was also another Supreme Court ruling where the Supreme Court sided with the cheerleader who wrote the profane social media message.
Yes. Well, I like this decision, actually. I love it. They said it was free speech for this girl to offer her frustrations on an independent, separate media about the school and the people at the school, because they had kicked her out, right? Because I think they suspended her because she made disparaging comments about the school and its teachers and administration.
The only problem that I have here is that I believe that there was another case where I believe an African-American child had written a post that involved, I think, some sort of rap music lyrics. And the Supreme Court wouldn't even hear that case. So I'm not quite sure what the difference is, why this one was more of a national free speech issue, more so than the other one.
Well, let's say, all right, well, let's see. So you're saying I go to high school and I'm posting stuff on my media, rap lyrics, or even just what if I'm posting poems that are just like gothic and about death and killing and stuff, right? Now, if I'm doing poems
as long
and
as
music,
it is not a direct
threat to somebody,
yes.
Right? Exactly, and that's what I was going to say. Is look, it's free speech to talk about whatever you want to talk about, as long as you are not threatening an individual, threatening to do crimes against individuals and things like that. So if I'm just putting out rap lyrics, you would have to interpret them as a real threat to something to even say that that speech should be
One of our viewers had actually sent me something regarding that, and I'm attempting to locate that issue. But
yes.
What was the difference in why they felt this particular speech was worthy of the Supreme Court hearing, but not what happened with the other kid?
Right. Now, she apparently just her remarks were as a response to how she had been treated in school and what she felt about certain individuals. And the court separated that and said that, well, that speech is on a forum that actually is not owned by the school, even sponsored by the school, so it can't be attributed to be done in the school by someone at the school, that it's over and above and outside of the school, and that it's okay for her to express herself in that particular fashion, because free speech really just means that you're not saying things that will cause havoc, riots, fights, threats to others, and things like that.
What the viewer had indicated was that NPR, National Public Radio, had done a story on the girl who wrote the cussing commentary on her failure to make the cheerleading team. And that's the case that the Supreme Court heard, basically ruling that schools cannot limit off-school profanity. But the reporter in that story questioned if the same would apply if it was a Black male teen whose conduct was similar. And there was a Mississippi young man who wrote a rap song, and the Supreme Court, and I believe that he was penalized by his school for it, and the Supreme Court refused to hear it. So I'm just wondering why his rights didn't merit a hearing with the Supreme Court.
Now, usually that occurs when the Supreme Court of the United States, first of all, we got to let you know, they don't hear everything.
They certainly do not.
They get to choose what they want to hear. And usually the basis of why they would hear it is because there's a dispute in one of the 11 circuits. Circuit 3 is disputing with Circuit 10 about the same federal law. And that's why the Supreme Court will want to step in. Usually it's got to be a federal law and a dispute over the Constitution issues or something like that. So here, of course, it'd be First Amendment issues. Can I put that kind of speech out for people to read, hear, and take in? So if they did not hear his case, then they had to have felt that because of the law of stare decisis, meaning follow the law that has already been done, that there's a case down below in the circuit that handles that factual issue. Now, that's the legal way of explaining why they may not have decided to hear that issue. And I bet you, because they're all political too, I believe that something like that, the Supreme Court probably didn't want to hear it because of the number of individuals who put out rap lyrics. That means all rap songs that may say something.
Well, no, because this again was related specifically to punishment issued by a school for conduct that I believe had occurred off school grounds. Again, it just shows that we live in a society where race, even though it is a social construct, right? We are all human beings. We all have arms and legs and eyes, and we all feel and we all breathe, and the same red blood runs through all of our bodies. But race is the social construct that has been created, and we have to deal with it as a society in terms of how it impacts us. And even if that impact is not purposeful, but it is subconscious. And we know in schools, it has been shown that African-American children have been punished far more harsher with suspensions and detention than other students.
Yes. So I think what you're saying, Carm, is that everything is equal until you throw race into the pot, and it kind of separates the oil from the vinegar or something like that, right? That now we are seeing differences in how people are treated and things like that. It comes out.
I don't know now that we're seeing them. Well, we've been seeing them because they have been happening ever since this country was formed. But we need to realize that and we need to address it and not sweep it under the rug and say we don't want to talk about critical race theory.
Right.
We have to talk about the history of race in this country and how it still impacts us today.
True. And I hear people talk about that, this critical race theory. We don't want to teach that, and then they go on to define, we don't want to teach our children that America might not be a great place or something like that. And I think they're totally missing the boat on that. They're totally missing the boat. I think you got to learn the truth in order to be proud of anything you're from. You got to know the truth. And what if we don't teach the children the truth and they grow up in this world with the subconsciousness, with having feelings that they don't even know why they may exist, then I think that's even more dangerous.
And it's dangerous. All the time we will hear people talk about history being rewritten.
Yeah.
Well, to say that you can't teach certain things is a rewriting of history, and we're not going to allow it. And we're asking our viewers to not allow it. These are discussions that need to be had.
Yeah. Especially when they're talking about changing curriculums, across the board, everywhere.
There is another court case that happened, and this was in Baltimore. The city of Baltimore had a spy plane program, and it was determined that program was unconstitutional and it violated the Fourth Amendment protection against illegal search and seizure, or illegal search. And law enforcement in the city cannot use any of the data that it gathered. There was a program, it was called the Aerial Investigation Research Program, which used airplanes and high resolution cameras to record what was happening in a 32 square mile part of the city. And this is really hits home because I think, again, a lot of people don't realize that when you step outside of your home, when you think about the technology that is out there, you are liable to be recorded in the public at any point in time. And case in point, my cousin Brian was actually visiting from Michigan, and he had a drone. And this was a really nice drone, but really compact. And we were in San Francisco. He sent it up into the air and captured almost the entire city. Just a view. And you could zoom in. He could zoom in on us on the ground. He could zoom in on people around us. He could zoom in on people blocks and blocks away. And so what I want people to know is don't think that law enforcement does not have those. Don't think that law enforcement will not use those tools to investigate. Even if they do not or are not allowed to use them as exact evidence, they can still use them for surveillance, to know where someone is, to know where groups are meeting.
Well, right now, when you drive through intersections, they have license plate readers that record the license plate. They have cameras that can take pictures of cars and things like that. So it is true. When you are out in the public, you are subject to being watched very easily.
And I would give a shout out to it was actually local African-American activist groups with support from the ACLU that sued the city of Baltimore to prevent them from using that data that they had collected. Do not think that Baltimore is the only city that is involved in doing that. And remember, at any point in time outside of your home, even if it's not law enforcement, because there's so many people that have home surveillance cameras on their home, and you are being captured in that video. Be careful.
Yes. And
we have a comment from Zimbabwe Walker saying they can't handle the truth. And I think that's in reference to
critical race theory. Yeah.
Yes. And just
the history of America
is the history of America. I mean, and that's one truth they're going to have to handle because we're not going to let them forget. We have a comment from Warren Mapp.
Yes.
This isn't the first time schools have done this. Years ago, if you were shown pictured with an alcoholic beverage on your social media, you would or could get expelled for that.
That's true.
And but the issue is, who were those expulsions and suspensions being applied to? Were they being applied across the board, or were they being applied to people of color?
Now, one thing about that, about pictures versus speech, is you may have those pictures up there, and I didn't take them, and I didn't authorize anyone to take them, and they're shooting my pictures and video of me out there. And so in that particular way, it's more of a punishment for bad conduct, that is done, instead of what you said may have caused a problem or something like that. So once again, though, what it brings up is this: if you're at a party, if you're someplace and you don't want people to take pictures of you, it's going to be very hard to hide. And you cannot dictate whether they post them on their website or anything. And I'll tell you, that's one of the things that we haven't seen. Well, what we have seen is people get stalked because of it. People cause, a lot of turmoil between people for doing such things. Let's just say if you take certain kinds of photographs and officers get a hold of it and you are being prosecuted for something, that could actually be brought and used in your trial. So you really got to be careful of who's filming you, what you're saying out on the web, because it can come back and it can bite you. And it might just not be just getting kicked out of school. You actually can use your job, because remember one of the biggest things with the stormers of the castle, right, was people were identifying them, shooting them back to their jobs and things like that, and people were getting fired and all kinds of actions going on. And they really can't do anything about that. They can't say, well, that wasn't me. That wasn't fair that you posted that picture of me storming the castle. You put it out there. You're there in public, and it happened. So you got to be careful of all of that stuff. Protect yourself at all costs. But most importantly, I guess today, is when we're talking about encounters with police, you have to know the rules. Know your rules. Know that what I'm saying is constitutionally backed. Know that all you have to do is read Florida v. Royer in 1983 Supreme Court case. You can Google it. It will pop right up on your screen. And read that case, because you will be amazed by the language that you do not have to help police. You do not have to talk to them. You can even avoid them if you want to. So do so if you do not want to be bothered. Ask the question, am I free to go? Before anything else is going down. And then listen for the answer. And then you'll know how to act appropriately from there.
We have a comment from Sheepdog Protector. It says Amazon Sidewalk also using the Ring camera to help police. And yes, and in many cities, what happens is people who have home surveillance can record their home surveillance, the fact that they have it with law enforcement, so that should anything happen, law enforcement knows to contact them to try and collect that particular video. And just so that people are aware, we do in our cases see that video being used.
Oh yeah. It's so many people who have surveillance now. I mean, and cops do know that's one of the first things they do. They go to the neighborhood and knock on doors. An
additional comment is, was Brianna Brochu ever charged for poisoning an African-American student and posting she did this online? From my understanding, she was only kicked out of the university. I vaguely do remember that incident happening. I don't recall there being any criminal charges filed against her, which is somewhat unusual, because if you poison someone, even if that poison is not, just enough to make them slightly sick
or something,
that is certainly a battery.
Yeah, for sure.
And I would argue a felony, because you're introducing a poison into someone's system.
And it could have led to something
far more severe.
And that's interesting.
Lawman, believe it or not, we're down to the wire, and it is time for you to give us that piece of information that you have. That
today I'm going to talk money. Okay, I'm going to talk money, because come July 1st of this year, there is a law that is being passed that's going to go into effect.
Well, it has been passed.
It has been passed. It goes into effect July 1st, and it will waive fees. I talked about it a long, long time ago, but it's in effect now.
Yes.
Which means payment of probation cost, payment of work project, payment of other court fees, except for a couple of mandatory ones, are all going to be waived.
So that means if you are on work project right now, and in fact, I had one of my clients call me and indicate that work project actually reached out to them. I think they either called or sent them a letter to let them know, and they had been paying a substantial amount, I believe $250 a month. To let them know that they would not have to make any further payments. And again, that is important because our society taxes the poor.
That's right.
And because usually who's involved in the criminal justice system that is going to have to pay these fines and fees that can't afford to pay them. And sometimes one of the reasons they're involved in the criminal justice system is because they didn't have enough money to live, and they committed some crime to try and get the things that they need to live.
And what's beautiful about it is just that when it goes into effect, it's in effect. So if you have a case and
where you were paying fines or fees,
and it's going now,
paying for work project, and this is across the state of California. This is not limited to Sacramento County.
Right. You do. So it's best to resolve your case after July to know that all those fees must be waived.
Well, even if you resolve, because this person that I'm referencing actually resolved their case over a year ago. So it does not matter when you resolve your case. A substantial amount of the fines and fees have now been eliminated.
Which is a wonderful thing. And that's, because they were taxing people a little bit too much. And so this is something that
and it's not really a tax. We're referring to it as a tax,
right?
But it was fines and fees that a person would be ordered to pay if they had been convicted of a crime.
Exactly.
And again, we see a certain lower socioeconomic group who can least afford to pay fines and fees being ordered to pay those fines and fees, and struggling to, I'm not going to buy groceries for my kids because I want to be out of custody so that I can work, but I have to pay the fees for work project.
Now, here's where there's really going to be an impact, okay? And I wish we had more time. We'll talk about it next time. Here's the impact. Let's say I've got a $5,000 bill at Office of Revenue and Recovery, okay? And it's gone to arrears. They're trying to collect it. My credit score is bad. Now, you can go in and they got to waive those fees. So I believe a mechanism of doing that is not in effect yet of how to do that, but that if it's still there, it should be waived. And that's what we're going to talk about probably next week, is how do you affect that thing? Do you just call up and say, hey, or are you going to now not get any bill anymore, or it's going to be significantly lower after they take the bill?
Be proactive and call in. And if you personally, again, may not have any of these issues, but you may have friends or family members who do. And so do let them know that a substantial number of the fines and fees have been eliminated.
Because you get your tax check, you get any kind of other bonus money, they will take that money out of that first.
They would have. And so now that should not be happening.
Right.
All right. We want to thank you all for spending another Friday evening, part of your evening with us here at Courtside. Have a good evening. Thank you for spending your time with Courtside with Lawman
and Carmen B.
Have a good evening.
Take care of yourself, please.